Of Civil Rights and Social Justice Civil Rights Bootcamp 2.1. We are so thrilled to have you join us for this national virtual conference bringing together advocates, attorneys, scholars, and community leaders committed to advancing civil rights and social justice. The Civil Rights Boot Camp was designed as a practical resource for young lawyers, law students, public service attorneys, and advocates of all backgrounds, offering real-world insights and strategies for navigating today's civil rights challenges. We hope you'll stay with us throughout the whole program. We have a stellar lineup of panels and speakers across the boot camp. A few housekeeping notes before we begin our panel right now. Number one, please submit any questions that you have through the Q&A function, not the chat. We're going to monitor the questions throughout the session and address as many as time allows. I welcome you to ask questions as we're speaking. You don't need to save them to the end. I think our panelists will be able to engage in a lively conversation with you through the Q&A function. So don't save things until the end. We want to make sure that we answer your questions in real time. If you're not able to see the Zoom controls, the chat, the Q&A, the captions, you'll just try moving your mouse or tapping the screen if you're using a touch screen to make them appear. As a reminder, this program is not for CLE credit, but it is being live streamed to CRSJ's YouTube channel, where it's going to remain available for on-demand viewing shortly after our program concludes. A recording will also be shared with everybody who registered, so please feel free to forward it to colleagues and networks who may benefit from this discussion. We also encourage you to explore the Zoom Events lobby, which serves as the central hub for the bootcamp. There you can view the full event schedule, access session recordings as they become available, explore speaker and sponsor information, connect with other attendees, and find additional bootcamp resources, materials, and announcements there. The section of Civil Rights and Social Justice regularly provides free webinars and resources for legal professionals and advocates nationwide. We hope these tools support you in your work. To learn more or to become involved, we invite you to visit americanbar.org/CRSJ, stands for Civil Rights, Social Justice, and consider joining the ABA and section of Civil Rights and Social Justice. All right, now let's get started. I am pleased to introduce today's speaker. We have Sam Boyd, who is a senior supervising attorney in democracy, education, and youth litigation team with the Southern Poverty Law Center. We also have Maya Brajuk, who is the Senior Counsel of Educational Opportunities Project for the Lawyers Committee for Civil Rights Under the Law, and Eva Dubison, who's an education law partner at North Carolina or at Tharrington Smith, which is a North Carolina law firm. I'm your moderator, Colin Sate. I'm also an education and civil rights attorney and really excited to get to talk with these experts today. You can read more about our backgrounds and expertise in your materials, though I imagine through our conversation you're going to learn a lot more about Sam, Maya, and Eva. We're at a moment now where schools are no longer just places of learning. They have become battlegrounds for identity, ideology, and power. The First Amendment has not changed, but how it is being used has in some respects. You heard some about that today earlier in the conversation about retaliation and whistleblower protections. We're going to dive deeper today in three broad topics: inclusive education, political speech in the educational environment, and then students' rights versus religious freedoms and parents' rights. As I mentioned, we're going to have dedicated time at the end for questions, but please ask questions along the way to discuss in those three topics: inclusive education, political speech, and students' rights versus religious freedoms and parents' rights. All right, panelists, to get us started, what are some of the things that you're seeing as the most complex First Amendment issues in schools going on right now? And why is it so dangerous for us as advocates to get this wrong? Maya, would you mind kicking us off?
Sure. So I think and thank you so much for having me here today. I'm excited to get into these topics. I think the biggest sort of concerning issue I see in the First Amendment and education space is the use of government speech as a defense to the censorship that state and federal governments are trying to do in education. We see state governments passing laws. We see the federal government doing EOs saying you can't teach this, you can't teach that, and then defending it in court by saying it's government speech and they can decide what they say or not. That's antithetical to what education is supposed to be. And so that's really something that's top of mind in the work that we're doing now.
Yeah, absolutely. We talk a lot about academic freedom in the education environment, and I think that what you just described really rubs against our academic freedoms. Sam, what about you? What are you seeing as some of the biggest issues we're facing?
Um, I think there's definitely been a sort of a new wave of attempts by states and the federal government to, exert ideological control on public education, on higher education, um, across the country and across the South. And I think that's, posing a bunch of new legal questions that frankly courts have not grappled with up until now. And so I think that's, some of what we're going to get into today, but it's challenging for advocates. And I think, more so for teachers and for school leaders and for others who are trying to figure out, how do we navigate this difficult landscape?
Yeah, somewhat of a fun, if not challenging, intellectual exercise for us as lawyers, but for the people that are dealing with it day in and day out that maybe don't find constitutional law to be something that they want to dabble in and think about all day, every day, and instead they want to go back to teaching kids. Yeah, that does present a problem for the people that are actually living their lives in the education space. Eva, what about you?
So I should say I represent public school systems in North Carolina. So that's the perspective that I come from in looking at these issues. I think one of the reasons that First Amendment issues have become more complicated and heightened lately is that, many of the questions that we're dealing with, student off-campus speech, employee political speech, are not new issues. But what is different now is that instead, so let's say you have an employee who makes some political speech online that is controversial. 10 years ago, we might have dealt with upset parents coming to a board meeting, or, some possibly media attention. But today, that speech is being scrutinized by much more by state and federal regulators and legislators who fund our school system. And so the tension, we're not necessarily responding to public disapprobation, but directly to regulatory action and funding issues.
Yeah, that makes a lot of sense. And kind of who's on the other side of the V shifts in that analysis? Are we talking about the parents or the teachers themselves, or is it this funding source? And so much of education laws are tied to funding, and there is a lot of power of the purse for, especially in K-12 education, but also in higher ed. Yeah, these are really important issues, and I'm really grateful that y'all are here to chat with me. I feel very honored to get to be the moderator of this discussion. All right, so let's start with our first topic, inclusive education. Maya, would you mind setting the stage for all of us, just looking at the need for inclusive education and what you're seeing occurring politically that's challenging inclusive education?
Sure. So inclusive education is the idea, sort of combines two separate ideas. One, the idea that schools environments should be culturally competent, and that includes the teachers, the staff, the students themselves, that there should be an environment in the school where everyone understands students and people's backgrounds and works to make sure that that place is safe and inclusive for all. And then the other aspect is this idea of inclusion, that when you're thinking about what you're teaching and how you're teaching things in schools, that it should be from a mindset of what can we do to introduce as many students and even teachers' experiences sort of in the materials and the books that we use and the topics that we teach and how we go about teaching them. This type of education has been scientifically proven through research to be better for students, not only for their well-beings, but also their academic achievement. And it's really something that we saw, particularly in the wake of 2020 and all of the protests around Black Lives Matter, that schools have really embraced and understood that this is what needs to be done now to make sure we educate our students so that they're ready to participate, in our country and our democracy in the future. And unfortunately, what we see happening sort of in the wake of all these changes to how schools are approaching education and approaching supporting their students is that there are some states, and now unfortunately the federal government, have started to see that as a threat and are taking steps to try and limit what can be used in schools to teach students, how students can be taught, even down to sort of specific materials or ideas, what can be taught. And a lot of these things, so they're not being labeled as sort of key parts of inclusive education, really are. They're taking away schools, books by Black authors. They're taking away books by LGBTQ authors, and they're making it harder for students who are not, white middle class sort of part of the majority to really feel welcome in school. And that's a really big problem. It's going to affect those students' well-being. It's going to affect how effective our schools are. And it's just not how we should prepare our students for participating in our democracy.
Yeah, really well said, Maya. Thank you. Sam, I know you've been looking at this, what's going on in the court system right now. Where are we seeing courts drawing the line between what is considered permissible curriculum control, versus what constitutes an unconstitutional viewpoint discrimination? And actually, let me back up one step from that, Sam. Can you lay out kind of the doctrines that we're talking about and then talk about what's happening now? What's different? What's the same?
Yeah, so there's a lot of different pieces to that. So what you're seeing in a lot of states is, and then also at the federal level, is attempts to pass, different variations on what are often called divisive concepts laws, right? Which say some variation on, it's illegal to teach this, it's illegal to require students to believe this, it's illegal for schools to provide funding to groups that espouse this. And then you get this long list of sort of vaguely worded concepts, frankly, which raises a whole set of questions around vagueness and notice and due process that I won't get into. So the first thing is that when it comes to setting curriculum for K to 12 schools, the state does have pretty broad discretion, right? The state can decide we're going to teach history of the United States and not Europe in 10th grade or whatever, right? That somebody has to set a curriculum, and that's basically the state's responsibility. But when you get beyond that, then the constitutional questions become harder, right? So at the higher education level, for example, courts have generally held that professors do have academic freedom, and that it's not permissible for the state to set the curriculum for them, right? So the state can sort of set, general education requirements, for example, for K to 12, but it can't dictate the content of professors' classrooms. And so we are seeing, now that is not necessarily true of university administrations, of boards of education, of, so what we've seen in like Texas and Florida, states are now starting to say, okay, fine, we're going to appoint a bunch of really ideological people to the board of the university. Then they're going to basically do that. They're going to, rewrite the sociology curriculum in Florida. They're going to issue these extremely restrictive guidelines that we're seeing now in Texas for what, professors can put on their syllabi, and that kind of thing. But sort of when you're just looking at it at the state level, professors have a lot more freedom. Teachers are generally government employees, so they don't really have discretion about what they speak when they're in the classroom. There are questions around if the laws are vague, do they have to have notice? Are there restrictions there? And they have much broader rights when it comes to their speech outside of the classroom, even potentially, on campus. Although that's definitely something that's been subject to a lot of litigation. And then students have rights. So students have First Amendment rights, even when they're inside the classroom. And I think one of the hottest issues right now in some of the litigation over the divisive concepts laws is whether they actually regulate student speech at all. So the states often are in a position of denying that they do so. Whereas if you actually read the laws, they could be interpreted that way in a lot of cases. And so, a common procedural posture is the students will say, well, I want to write a book report about this, and I'm not allowed to because that's a divisive concept. And the state will say, oh, no, you can definitely do that. And so then it goes to court, right, about whether or not that's a reasonable fear. We saw that in the Don't Say Gay litigation, for example, which is one of the earliest of these laws folks may have heard about. It barred teaching about sexuality for certain grade levels. And so, the state eventually took the position that anything a student did was not teaching, and that was separate. And so that wasn't regulated by the law. And so I think there's a settlement, and that's now what everyone in Florida understands that law to mean. But before you get to settlements like that, before you get to litigation and before it's resolved, schools often kind of take the most conservative possible position, which ends up being very restrictive, not just of curricular speech, which is sort of at least arguably within the state's control. It becomes restrictive of student speech and speech even outside the classroom by students and by teachers. And that's, really troubling from a First Amendment perspective. And I should also say, even in the classroom, speech by teachers, I would personally not want to concede that that's entirely free from First Amendment scrutiny. I think to the extent that the government is sort of, trying to advance a particular ideological line, there are First Amendment issues there. There's issues around discrimination, equal protection of students, of teachers. But those are ones that, I think are definitely still unsettled in the courts.
Yeah, thank you, Sam. And also, a question that remains open for in this space, I think, is what is an ideological line? Like what counts as ideology these days is a question that I think we're all struggling to answer. And one of those cases that where this came up was the Mahmoud v. Taylor case that just came through the Supreme Court over this past summer, that ultimately required a school system to allow parents to opt out of particular curriculum demands, or supplementary curriculum demands. But Maya, if could you give us a little background on the
Sure.
Mahmoud case and correct that I just messed it up myself? Make sure that the audience gets it right since I can't. And then also kind of tying off of what Sam just said about how that's being impacting curricular decisions.
Yeah. So yeah, the Mahmoud case is very interesting because I think so this is a case involving parents who had objections to certain parts of the curriculum that schools in Montgomery County had set. So this was curriculum related to younger students in elementary school. They had included as part of sort of their teaching and providing books that discuss same-sex relationships, same-sex marriages. And it's sort of along the lines of what inclusive education is. It's perfectly likely that some of the kids in this classroom have parents who are the same sex, who are married, who are not. And so they're including materials so that students are exposed to and sort of understand that this is part of our society these days. Parents were informed that these books are sort of part of the curriculum, would potentially be read in the classroom, would at the very least be sort of available in the classroom libraries, and they raised objections for their students to participate in any lessons sort of involving those books, saying that the messages in these books violated their religious beliefs around same-sex relationships and marriages. And so it went up to the Supreme Court and basically asked the Supreme Court to decide whether or not parents would be allowed to have this. And so sorry to back up just a little bit. It is a very complicated case. There were enough parents that tried to opt out that sort of creating an opt-out system around this aspect of the schooling became sort of untenable for the school districts. And they said, we can't provide religious opt-outs. There's no way for us to sort of manage what to do with the children who are opted out while teaching the rest of the material and this and that. And so parents then sued so that they would be able to opt out when the school had decided they no longer would be allowed to for this sort of part of the curriculum. And so went up to the Supreme Court, and the Supreme Court ruled that parents that needed to be allowed to be opted out in order to protect their First Amendment religious rights. This case is interesting in many fronts. What's interesting sort of in the inclusive education curriculum side of things is that the school districts and even the parents were all aligned on this idea that no, the school is allowed to decide what the curriculum is. The parents were very clear that we're not trying to challenge what schools are deciding to teach. We're just saying that we don't want our students, like our children, exposed to this, and so we want to pull them out. But at some point, that I think as the school districts are trying to get that becomes untenable. If everyone in the classroom opts out of a certain lesson because of their religious objections, then whether or not it's sort of officially listed in the curriculum, it's not being taught anymore. And so the parents are in some ways affecting what decisions the schools are making about what can be taught and what can't. Even more sort of in the sort of chilling line of ideas, like if a school district knows that a certain topic or certain books or a certain area is going to have a lot of objections, they know it's going to be a real headache to try and implement administratively, they might decide not to teach that and avoid having to deal with all of these issues. That's exactly the sort of thing that we don't want to happen. And it's particularly concerning in places like Montgomery County that really are adopting inclusive education and are really trying to make these great pedagogical decisions for their students, feeling this pressure from parents to sort of change things. And so it really puts a lot of these different issues at a head to try and figure out what right is going to be able to overcome another.
Thank you, Maya. That's super helpful. And again, it raises that issue of what counts as ideology. What kinds of things can people opt out of? Is it only LGBTQ related supplementary books that are available in the classroom, like was that issue at Mahmoud, or is it bigger than that? And North Carolina, following the Mahmoud decision, actually passed a law, in many ways codifying this in the North Carolina law. So Eva, I would love to hear from you from the school side of things. How are schools dealing with this? What are they supposed to do? How does this function in reality now?
So that's right. North Carolina essentially enshrined the parent opt-out in statute, among many other provisions of our Parents' Bill of Rights legislation. And in the day-to-day, I think one of the things that's frustrating for us about Mahmoud is obviously it is a holding that is very difficult to implement. From the institutional perspective, also felt like a case of, to paraphrase, regrettable facts making a regrettable law, in that it the scenario where the district was taking such a firm line and there were so many parents with such a clear religious objection, somewhat unusual in our area, and also seemed like there ought to have been some room for a little more compromise there. But I think, obviously Maya and I come from a different perspective on that, where, the school system, the school board is elected. And if that large of a portion of your population has a certain concern, many school districts would be responsive to that. But I think in the day-to-day, what we're seeing is, as Sam mentioned, with these, both with the terms of Mahmoud and the statutory parental opt-out, is really the difficulty of determining, our Parents' Bill of Rights says that you will not teach about sexuality and gender in K-3. Well, if you ask pretty much any K-3 teacher, they're going to say, I'm not teaching sexuality, right? I'm teaching math, reading. That takes up plenty of my time. And so and then of course, as Sam said, the state, in coming into court to defend their bill, will need to sort of narrowly construe it as well to the definition of sexuality. And so then what the legislators think they are getting at, and what they have written, that gap is really difficult to navigate.
Yeah, that's a really good point. And what I'm hearing from you and from what Sam was saying is we start out with these extraordinarily broad laws, and then when we start looking at them, or they start getting defended in courts, or they actually are coming into the application, they do get chipped away and narrowed. But they come out of the gate looking like these broad, sweeping laws that may not necessarily comport with existing Supreme Court precedent, or statutory precedent, depending on where they are. Which again brings us back to what counts as religious views. What are these ideologies? And Sam, I know that you've looked at that some, and what courts are saying about this counts as a religious view and this doesn't. I would love to hear more, and I think that many of the advocates that are listening to our conversation today would appreciate some clarity on that as well.
Yeah, and I think this is definitely, I mean, I don't have an answer really about what courts are doing, but I can speculate about what they might do in the future, because this is really a very new issue. But just to get back to the question of laws, just to kind of put a finer point on it. So I think, and to what you're saying, Eva, I mean, I think the Florida legislature, for example, when they passed the Don't Say Gay law, they absolutely thought they were banning teaching, a book that, like the one at issue in Mahmoud, that discusses the existence of same-sex relationships, right? What they didn't want was they basically wanted to ban content about LGBTQ people at least from elementary schools. But I think some lawyers in their office, realized that would be really hard to defend. And so they instead wrote it as, content about sexual identity, right? But, depicting a gay couple is no more depicting sexual identity than depicting a straight couple. But you're now also seeing people try to go further, right? And Mahmoud is one example, right? The parents there, they were not objecting to teaching about sexual identity. They were objecting to this book that they thought conveyed the message that same-sex relationships were morally acceptable. And they won, right? So they got the right to opt their kid out of that. And as Maya was saying, that may, in a lot of cases, mean opting all kids out of it. So I think the next step is, well, what happens when, you've got some other mom who's got a kid in that same classroom with the plaintiff in Mahmoud, who says, wait a minute, I have a religious belief. Maybe I'm, from a church that's affirming of LGBTQ couples, right? If you only show my kid, heterosexual couples, you're teaching him that that's the only acceptable kind. I object to that, right? And so I think we are going to pretty rapidly start to see, to the extent these claims, there are a lot of these claims, which I think remains to be seen, how many parents actually want to go to the trouble of putting in an opt-out like this. But to the extent there are a lot of them, and to the extent they do start to influence curriculum, with schools just saying, we're just going to kind of do the thing that the conservative people want us to do because that's simpler. And logistically, will you see a wave of folks from the other side pushing back and saying, that's just as much discrimination against my religious belief as the opposite? And if that starts to happen, is that going to go beyond? I mean, right now, sexual orientation, gender identity, that may be the most prominent one, but there's certainly folks who have, very strong religious beliefs around, teaching the history of race and equality or poverty
Evolution
or,
in biology
lots of,
class.
yeah, exactly, lots of other issues. And the question of sort of what even counts as a religious belief, I think, is not one that courts have said very much about. There is some case law saying that even some, you don't necessarily have to believe in a deity. You don't necessarily have to believe in, have an organized church, right, in order for something to be a religious belief. That the general tendency has been both to define religious beliefs broadly, and then once you've identified something as religious belief, courts entirely stay out of the question about whether or not, once you've identified a religion, what that religion says, right? That's not a question courts are going to. If I say I believe it, if I sincerely believe in this religion X, and the courts agree with that, they're not questioning my sincerity. Then if I say that means I can't wear, purple hats on Tuesday, they're okay, great. That's what your religion says. We're not going to question that. And so, when you add those things together, and then you start sort of creating a right to exceptions from generally applicable laws, which wasn't available until recently, I do think you pretty rapidly start to see a situation where schools may be left with no viable alternative. Right? It may not be possible to teach a class that sort of satisfies the religious rights of everybody involved, and so I think unfortunately we may see some chaos, and how much courts take seriously the implications of these different conflicting lines of cases, I think is going to be an interesting question. I think there's unfortunately a tendency sometimes in religious freedom cases for the courts to kind of pretend that they're obeying those laws that I just said, but actually really only take seriously the religious rights claims of Christians, primarily, and then just to a secondary extent, the followers of other, longstanding organized religions. But that's not what the case law says they should do. And so remains to be seen, I guess.
Yeah, that chaos is something that I think we all should be prepared for and looking out for. Because I do think that I think Sam, just you're dead on that this really does have the possibility to throw a wrench in a whole lot of different things. Because at the end of the day, Eva, as you well know, the school systems still have to teach the standards, right? The curriculum still exists, and if everybody has a different religious objection to different ways to teach the standard, how are schools going to be able to do that? How are we going to continue to have a public education system for all? It's a big open question, absolutely. All right, I want to keep us rolling. Eva, I want to come back to you. When we're looking at these, whether it's a religious opt-out of an individual thing or a book challenge, because I know that has been a big issue in schools, I mean, forever, but certainly perhaps more so right now. What does that process look like, just practically? If our advocates on our call today are interested in taking Sam up on seeing where this chaos lands, just how does that work? How do school systems evaluate that?
So all of our clients, and I assume most school systems, have really detailed book challenge procedures that come out of the PICO decision. Like, this is not a new process at all. They've had them for many years. And it generally, so if someone wants to challenge that a book shouldn't be in the school library or in the curriculum at all, that's the process they're supposed to follow. And it's, it starts with a committee at the school, and it's like more than 5, but less than 15 people. And they have to have this type of person and that type of person. And they all read the book and then come to a decision about it. And then it can be appealed to the superintendent, then it can be appealed to the Board of Education. And so it's a lot of process, and it's a good, solid process. I think what we're seeing is no one wants to follow that process. So it is a lot of work as a parent, and also not that glamorous and doesn't get you that many views. And so what we see is folks sort of skipping ahead to public shaming, right? And skipping ahead to like reading all the dirty parts of the book at the school board meeting where there's cameras, instead of challenging it through the committee process. The other problem we are having with the book challenge process is, we have sunshine laws like every state, and the documents being generated and so forth are public records as that's going along. And when we do get someone to file a book challenge in recent years, it is really hard to get staff to serve on those committees because their names will be on the documents. And that can lead them to online reprisal, doxing, etc. And so you have to have like a really dedicated school librarian who's willing to kind of brave that. So those are challenges. I do, with regard to the individual parents challenging the use, like wanting an opt-out, we certainly do see that. I will say that really in the last 3 years, technology has helped us there. I mean, it doesn't, from an advocate perspective, it may not be helpful, but it's a lot easier to have a system where a parent can opt their child out of things without impacting other children, because now we have digital library cards and digital library catalogs. And so we haven't seen when these things first started bubbling, our schools were very nervous about implementing that and how to keep track of when a kid is looking at a certain book. That has really gotten a lot easier with the advent of software. And so there hasn't been in our area a lot of disputes about that. It is sort of not a lot of friction if a parent says, I don't want my child checking out certain books. So when we do have book challenges, it tends to be at the level of public discourse rather than at the school level.
Thank you for that, Eva. Maya, how are you when book challenges come up or curriculum issues come up? How are you seeing that impact students as well as teachers in their day-to-day?
Yeah, I mean, I think in this environment, teachers, even when they're not subject to a specific sort of censorship law or their school districts aren't doing anything, are in general sort of fearful about teaching things that are more controversial or really diving in deep to those materials. They are worried about a parent, making an objection, it becomes a thing and they're the center of it. So there is sort of a lot of fear, and there's a lot of this chilling effect, which is what the First Amendment is really supposed to protect against. When we see teachers making a decision that's less likely to sort of put them at the center of some controversy. I do think on the student side, particularly when you're dealing with older students like high school students, we have a case in Arkansas where Arkansas passed a education law. Part of it included sort of an anti-CRT indoctrination provision, relying on that. An AP African American Studies course was sort of changed within Arkansas so that it wasn't given the same sort of level and credit as other AP courses. And I think what was really interesting and also sort of fun to see is telling high school students that, like, no, the state says you can't learn this, it's dangerous. Really, it's a great way to get students very interested in whatever they're being told they cannot teach. And so we, Lawyers Committee, along with some great attorneys down in Arkansas, have challenged that law. But beyond even our legal challenge, students, organized themselves at schools that had taken this course, that wanted to take this course, and protested and said, hey, like, we want to learn this. This is important. We want this information. And a lot of the students took the class, even though they weren't going to get credit for it. And first thought they might have to pay for the AP course themselves. They were committed. And I think that is one. It's obviously sort of limited because the elementary schools and middle school students aren't maybe as involved, but for high school students specifically, again, you tell them what they can't learn, and all of a sudden it shoots to the top of their list of things they must have and must learn about. And so it is it's a great way to get students more involved and sort of realize what the forces outside sort of their schools are, and then get them to learn this really incredibly important information.
Yeah, thanks, Maya. And that I think opens the door to my next question of what are some things that we as advocates can do in this space? What are techniques that people who want a more inclusive curriculum, what kind of techniques can we take to advocate for that? One might be, Sam, as you mentioned, most of these laws, when challenged, legislators are backing off and saying, we're not saying students. Students can still learn what they want to learn, say what they want to say. that have a project on whatever they want to have a project on. That may be one way that advocates take a turn is, all right, well, let's empower students. Let's make sure students know what their rights are in the classroom and understand what they are or are not allowed to do and how these laws are or are not impacting their speech. That may be one way that we take this. But what are some other things that advocates could for an inclusive curriculum can do in the face of these sorts of laws? And Sam and Maya, looking at you guys first.
Yeah, and I did see a question also in the Q&A, being like, okay, it's all great speculation about the future, but what can we actually do right now? So
Yeah, what
that's
are we
a
gonna do?
good, yeah. I mean, I would say, push back, right? Push back using all of the legal tools that are available. Um, I think that could be filing your own kinds of objections, right? Not just letting one side of things, challenge books. In Florida, where I do a lot of work, the book banning process really got kicked off by some legislation that was passed back in 2018. And there's been some incredible mobilization on the ground by advocates, group called Florida Freedom to Read, most notably, um, you know, going to every school board meeting, right? And when parents, when you have, one Mobs for Liberty person comes in and challenges like 50 books, a whole bunch of parents come in and are like, actually, these are really valuable books, and here's all the reasons why. Here's why they don't meet the statutory criteria. Here's why they have, redeeming artistic merit. Um, and most of those challenges, have failed, have been rejected because when, I think folks see that these challenges are only being made by a small group, that is sort of enough to convince, even in pretty conservative places, often convince school boards to keep them on the curriculum. And the same thing I think is true of curricular changes, right? Like, if you have a school board that's thinking about, okay, it's just too much work to have this book because some small number of parents are going to have the right to opt their parent out of it. Like, represent those other groups who want to keep that book in and say, like, look, we have rights too. We're going to file our own challenges. We're going to, we have religious rights. We have equal protection claims that, if you're a child of same-sex parents, for example, I think you have a quite strong equal protection claim if your school tries to erase the existence of your own family from the curriculum. And so I think, the only solution, I think, to some of these things is going to be to push back, as forcefully on the other side, whether that's through, legal challenges, using some of the types of claims we've been discussing, or advocacy, or, ideally both.
Yeah.
Sorry, I'm
Maya,
making Eva's job just harder and harder, but it's my job.
Yeah, I can add on to that. I mean, I think sort of in the vein of what Sam was saying, and particularly earlier, like the chaos is a good way to respond, right? Like, I think a lot of these laws are banking on the idea that the people who are really invested in them will work with them and push things to change, and everybody else who is likely even in the majority is not going to do anything to push back. If you do start pushing back, that creates a whole different dynamic and becomes a lot harder to enforce those laws. Becomes a lot harder for those laws to be enacted the way that the people who created them can. So just the sheer act of sort of standing up and saying no, or like I disagree, can often be really powerful. I think, again, going back to this idea of the First Amendment, like a lot of these laws assume that the chilling effect is going to do a lot of the work, and they're not actually going to have to enforce the laws. Teachers will be scared, school districts will be scared, and rightfully so, and will make the changes, and no one's going to do anything. And I think the best antidote to the chilling effect is to say things, like name it, say it out loud, and then all of a sudden everyone else can see, like, oh wait, like you're like, we're worried about this, but you're still doing it. Well, then I can do it. How did you do it? Like, now we can form a network, right? And so whether that's teachers talking to each other and being like, how are you teaching it? Oh, you're teaching it too, then I can teach it. That's students sort of saying, like, we want this to be taught. Look, they're learning it over there. I want to learn about it. I can't go to college if I don't learn about it. I'm competing against these other kids. And so really sort of saying, like, no, this is not okay, and calling out sort of the chilling effect and saying we're not going to stand for it. And I think you see, in the cases that we've litigated and others that we've been paying attention to, when states are forced to defend these laws and come into court, all of a sudden their interpretation of what this law is and how much it covers is drastically smaller than a lot of the rhetoric that was talked about when these laws were being passed in the first instance. And you get that message out there, and then all of a sudden the law can become sort of a big nothing burger. And that's really what we want.
Yeah,
Right.
I think that last piece, just to jump back in, is really important. That the first instinct of a lot of advocates is to talk about how terrible these laws are and all the good things that they ban, which I think is has its value, but it has meant that people listen to that, right? And no one's actually reading the laws, right? So the folks on this call are all lawyers, I presume. And so like you can pull a statute and you can actually read the words, which I guarantee you will have done more work to understand the law than the school board members involved. Maybe not, but don't mean to Eva's clients, but most of them, I will say. Or even, the teachers or the school officials, right? I mean, we've had folks say the law bans this, and it just doesn't. Like, you read the law, it does not ban that. That's not in any way, shape, or form what the law covers. And like educating people about that and then pushing back when school boards take decisions that are beyond what the law requires, I think is a really important step for lawyers to take.
Yeah, thank y'all so much. That's very, very helpful, and I think answered our friend's question. I was like, okay, well, like, what do we do? What do we do? There's plenty. There's lots to do in big and small ways. So thank y'all for that. I want to make sure we don't run out of time for other two topics, though. Political speech in the educational environment, or sometimes outside of the educational environment. Maya, sticking with you for a minute, can you set a stage for this one on what are we looking at in terms of regulating employee speech on campus, and then we're going to turn to student speech off campus. But first, let's start with employees.
Yeah, so for employees, this idea of sort of government speech comes into play. The idea being that public employees are going to be limited in how they can sort of do their jobs by what the government tells them they can and cannot do. And so in the instance of education, teachers are public employees. And so they are bound by what the states, but what school boards say about what they can and cannot teach. And when they are speaking in their role as teachers, what they can say can very much be limited by those restrictions. And especially with recent case law, that's sort of that line is pretty clear. I, with Sam, don't think that necessarily should be the case, but alas, the First Amendment at the moment doesn't give a whole lot of leeway there. I think, as both Ava and Sam had alluded to, when you get to teacher speech, even on campus, but sort of outside of that narrow, like, I am teaching material to students now, the lines become a lot more blurry, and there's a lot of sort of case law that's being developed about what teachers can say. Can they be punished for what they're saying? But in terms of sort of teachers teaching the curriculum or teaching in classrooms, right now the line is pretty strong that, as public employees, they're limited in what they can say and do by their employers, the government.
Right. Absolutely. And especially on campus.
Yeah.
But following, this has been happening for years, but particularly following the Charlie Kirk killing, there was, I think, an influx of off-campus speech that was coming to a pain point for teachers with their jobs, with their employment in the educational environment. Eva, will you set us up for what was going on there and how teachers were being impacted?
So, yes, certainly after Charlie Kirk was killed, there was a particular focus on, and it's really, we're talking about social media, right? It's employee statements on social media. And social media has changed this calculus in a lot of ways, because if you think about, the rights of employees to political speech, I don't think have changed that much. And as you said, outside of the classroom, like curricular speech, certainly in the Fourth Circuit, K-12 teachers have very little, if any, First Amendment rights there. But outside political speech, what has changed is the porousness of the border between classroom and not classroom because of social media and the internet. And so if you imagine, in the Tinker era, a teacher spotted at a Vietnam War protest, a couple of parents are upset about that. It's very hard to argue that that's impacting the teacher's ability to teach. Today, every kid in that classroom has a device in front of them and can be looking at what their teacher is saying if online and sending it to their parents, and then it can impact the teacher's relationship with students. And so it obviously it makes things a lot more gray. I think what school districts faced certainly were calls to remove certain employees because of their online speech. As I mentioned, complicated by the fact that many of those calls were coming from federal and state legislators and regulators of public schools. And so that that made it more challenging. I think the case law has been fairly solid in continuing to hold to the First Amendment protections of those employees. But what we do still struggle with is how to define when someone's off-campus speech is impacting their ability to do their job. And I always try to give school employees sort of the counter example, certainly posting a public statement, about ICE doesn't belong in schools may seem like it ought to be very protected, but only if you also think your child's teacher should be able to post a public statement that says they think ICE does belong in schools, right? From a First Amendment perspective, and trying to, and how that would impact the teacher's relationship with students depending on the community.
Yeah, that's a good point, Eva. Thank you. Following the Charlie Kirk killing and teachers being their social media being exposed to school boards, whether that's from state legislatures or parents or otherwise, many teachers lost their jobs during that time. And Sam, if you can share with the audience kind of what happened after that and how that all played out.
Yeah, I mean, I think that was, to be frank, a pretty shocking example of cowardice on the behalf of public officials all across the country. Because in a lot of those cases, I think teachers were acting just completely obviously within their rights as public employees. So the standard, this sort of builds a little bit what Eva was saying, the standard is when you are speaking as a private citizen, right? So you're speaking outside of the classroom on a matter of public concern, you you can still be fired for that as a government employee, but only if the government's interest in that firing outweighs your interest in the First Amendment protected activity, right? And so the only sort of justification for that is if your speech is causing such a disruption to your job that it prevents you from doing your job in some, material way, right? So like an example would be, you're a police officer and like in your private life, you're a KKK member and, the public knows that. And so like nobody takes you seriously, you have understandable problems interacting with non-white people in your job. And so you can't do your job. So you can be fired. That's the thing. I would say I'm not aware of any of these Charlie Kirk cases. There being examples, there being actual evidence of disruption. Sorry, that was just a hypothetical. I probably should move beyond that. But the basic point is you're generally, as a public employee, allowed to engage in First Amendment protected activity outside of your job, even on the job. There's a Supreme Court case where one public employee said to another about the attempted assassination of President Reagan, "I hope they get him next time." And the employer fired the employee because they thought, hoping the president's murdered is not a good thing. I don't like that. I'm going to fire this person. The Supreme Court said that's not constitutional. If it had caused a big controversy at work, if people had been arguing about it and fighting about it and it disrupted the workplace, that might be one thing, but there wasn't any evidence of that in the record. And so that you're firing this person basically for having a First Amendment protected activity. Most of the Charlie Kirk cases I'm aware of, maybe the school got some calls, maybe people came and yelled at a school board meeting, but that was kind of it, right? And so, I think we've seen the outcome of the litigation in those cases has been, as far as I'm aware, every teacher who's brought and other kinds of public employees who've challenged their terminations for Charlie Kirk related speech has won if it's gone to a judicial decision. I think there's one counterexample now, one district court that came out the other way and found there was evidence of disruption. But most of those cases have settled because I think the states, the school boards and other defendants have realized they just don't have a defense.
Yeah.
There was a public employee in Texas at a state university who was fired, settled for reinstatement and $500,000. And so,
Good deal.
I think there's the courts have been good at standing up for people's rights in this area. And, I hope next time something like Charlie Kirk happens and people make, what were in many cases really innocuous comments, their First Amendment rights are more directly recognized by the people who make these decisions.
Right. And it's the same, a similar vein that we just saw with the curriculum decisions is we start with these big, bold, out of the gate, we're going to fire people who make these sorts of statements or whatever. And then as they actually start coming into court, we wind up in settlements, we wind up with judicial decisions. And so I think a lesson that I'm taking from you, Sam, and as well as you, Eva and Maya, is that um, don't be chicken little in this. That really look at it and really see if this is um, worth standing up for, and if so, we're seeing a lot of wins here. And then what I heard out of this conversation, as well as for advocates that want to defend these teachers that are being punished for whether it's, I want to say, non-curricular speech, whether it's in the school setting at their workplace, but it's not part of teaching, or outside of the school setting that really impact seems to be the biggest component, the biggest argument for do I get to keep my job or don't I is the degree of impact. Thank y'all for that. All right, I want to make sure we talk about students though before we move on. Is students' political speech. Eva, there was a big case that came out a few years ago in the Supreme Court, Mahanoy District versus BL, and schools having less authority over off-campus speech, but not none. How is that working right now in this political environment? What are you seeing with how school systems are regulating off-campus speech? What courts are saying? What has anything changed in the past couple of years?
I would say that, partially just compared to 10, 15 years ago, where students, student online speech was just a newer thing, and the types of things that were being said were more shocking to people, and now school staff are just somewhat more used to it, and less likely to seek to punish off-campus speech simply because there's so much of it and they would never do anything else. I will say that what is difficult about the Mahanoy case, where a student posted some things off campus, then that were critical of the school and school staff, and then was disciplined on campus, is I feel like we still really don't have good guidance on off-campus speech that is critical or harassing of other students. And that is where most of our difficulties and conflicts arise, is off-campus online speech, texting, etc., of other students, and where the line is in a Mahanoy type scenario between, okay, well, that was purely off campus and the school simply doesn't have the reach to reach that speech, versus, okay, but it was causing what the victim would say a hostile environment for them when they're, even though that happened off campus. And, previously we had some pretty good case law about, if you are harassing a student, bullying and harassing speech not being protected because it's sort of understood to be a disruption under Tinker. The Mahanoy decision said bullying and harassing wasn't at issue, but said, well, harassing or bullying speech that is off campus could be considered a disruption if it's severe. And it's dicta, but it certainly threw us into uncertainty as to what is severe. And every parent whose student is being bullied online is quite sure that it's severe. And so we really still don't have solid guidance. And I think Mahanoy sort of took away some of the clear guidance that we had, and did not replace it with a new analytical framework for the student speech.
Right. Still looks like we continue to ask the question of what was the impact on the school environment, and maybe a sliding scale of how much schools can step in for students or employees. Eva, what about on-campus speech? I know there have been a number of pro-Palestine protests that are happening on campuses and off campus as well. Same thing with anti-ICE protests. How is that playing out in school systems? What are school systems doing especially when they're taking place like in the educational environment on campus?
That's right. And the pro-Palestine protests were particularly difficult, I think, because some of these issues are issues that school staff are very familiar with. The Israel-Palestine conflict was something that we had not as schools had to deal with a whole lot, you know, and people demanding that their school board put out a statement or have a position on that war sort of threw out a lot of anxiety and caused a lot of anxiety because it just simply was outside our wheelhouse. My experience is that, first of all, again, we have, you know, as lawyers, we have the conversation about make sure that you are treating the pro and the anti-protesters the same, and that you would do the same if the student's message was the opposite. But the general approach has been a practical one. I think that schools could regulate that, you know, walkouts and so forth under their code of conduct. Most in my area choose not to, and choose instead to sort of take a hands-off stance of we are going to look at safety when there's a walkout. We ask that you let us know in advance. We are going to check to see who leaves and who comes back so we know if anyone's missing, that sort of thing, and really focusing on practically trying to protect safety. I have in most cases seen, and I think the system is principals working with the student organizers to say, look, I understand you're going to protest. I'm not going to stop you, but can we agree to put it in this part of the courtyard so that it's not blocking dismissal or whatever? Generally, those sorts of arrangements have, you know, both sides have been open to that. And so generally that's what I've seen day to day is more of a focus on practically maintaining safety. You might get, you know, you could get detention for walking off school without permission. But honestly, the administration of such a punishment is an enormous headache, and I haven't seen it used a lot.
Yeah, that makes sense. Sam, Maya, before we move on from our political speech, any thoughts, comments, inspiration for people that want to help teachers or students that are, you know, trying to have more political speech in the environment?
I think just that, you know, these are areas where there is a lot of good case law. The Supreme Court, you know, still protects First Amendment rights for the most part. Attorney's fees are available, so I encourage you all to take these cases.
Yeah, thanks, Sam.
Yeah, I think is applicable to political speech, but also sort of broader. I think we see a lot of headlines of really bad things happening, laws being passed that seem really dangerous, really broad. We see, you know, teachers, students getting punishments for protesting, and that's sort of all you see. I would say, sort of in the general news media, there's not always a lot of follow up of what happens, but if you look and see what happens after, a lot of that is changes. You know, the laws are found to be vague or violating the First Amendment, and they're narrowed or are found to be sort of unenforceable. People who got punishments in the first instance challenge it and are able to get it reversed. So not taking sort of at face value what you see as the first step, and really looking to see what else has happened and seeing if there's, you know, law that you can use to support a case that will challenge sort of these bad things. And you will be successful, I think, a lot more than you might think if all you see is sort of like the first flash headline about stuff like this.
Yeah, that's super helpful. And Sam, certainly inspiration to bring lawsuits is great with attorney's fees. But there's also school systems are going to have administrative processes in place as well for students to appeal or teachers to appeal disciplinary decisions. And sometimes a principal or a school will make a decision that the school board itself is not prepared to defend and does not want to defend. When they call their great attorneys like Eva and she says, hey guys, you don't have much ground here. That just following the administrative processes and getting it elevated far enough into the school board level can get different results without ever having to go through a federal court case, can change to policy changes, can lead to that shrinking of impact that we see happening the in the law, but also within board policy as well. There can be some growth areas there that school systems are willing to take outside of a full-blown federal court case. So I want to make sure folks know that there's tiers involved in this as well. All right, before we run out of time, we've got to talk about parents' rights, and we've been watching a collision over the past several years that is only escalating, I think, between parental control over child's upbringing and how that plays out in the education environment with the students and their rights and their abilities to explore as teenagers and preteens and what that looks like. So Eva, I want to start with you. North Carolina has a Parents' Bill of Rights. Sam's referenced the Florida one a lot as well. What is this? What does that look like for audience members that are not as well versed in what these Parents' Bill of Rights actually look like? What do they look like, and how do they play interplay with students' LGBTQ identities?
So North Carolina's, and they look very much alike across states. I will say that Florida's experience led to subsequent bills being written more narrowly, and North Carolina's is, for instance. So it lists a number of rights of parents, many of which already existed. Some of which have to do with opting out of curricular or challenging and being able to sort of view everything that your child's going to be exposed to at school. With regard to LGBTQ identities, the focus is generally on pronouns. Although, at least in our area, it mostly addresses what students are going to be called. And so the North Carolina, for example, says school staff cannot change a student's name or pronouns that in response to the student's request without notifying their parents first. And so I will say, and that is much narrower than where they started in Florida, where it was essentially you can't change their pronouns regardless. And so what it means practically is working with, again, at the school level, they're concerned about the admin of it all, right? How are we going to know whether a parent's been notified? How do we know if it's a change or if the kid's been called junior his whole life? And so honestly, setting up processes by which, okay, if anybody wants to change their pronouns, you have to notify this person, and then they call your parents. And North Carolina's law does leave room so theoretically, if a student comes and says, I want to change my pronouns from now on, please address me as this. And the teacher says, I can't do that until I notify your parents. And the student says, please don't. You can stop there. North Carolina statute does not require that you notify them, but it does say that then I have to continue to refer to you as if you don't want me to notify your parents. And so once we sort of sussed out what that actually means, largely, it is most children who come in wanting to make those change with adults as opposed to with their peers, which is still their own business for now. It's a pretty rare case that they don't have parental support if they're coming to the adults and asking them to change it doesn't never happen, but certainly most cases their parents have said, yes, great, please do follow their request. So that's what we've seen so far. But that's how it's playing out here in North Carolina.
Yeah, and Eva, what I heard part of that when we look at like how can we do advocacy in the space, again, an emphasis on what students can do with other students is different than the teacher to student relationship. So again, if anybody wants to go make student write pamphlets about this, I think this could be really beneficial for kids to know like how do these laws actually impact them personally and what they personally are able or not able to do. Sam, there's also states that have the exact opposite policy. So instead of prohibiting teachers from or requiring teachers to disclose certain information, it prohibits teachers from disclosing certain information. That's playing out right now in our Supreme Court. Can you update the audience on what's going on with that California case?
Yeah, so there was a California law that prohibited schools from outing students to their parents without the student's consent. Some parents sued over that, and the Supreme Court issued an order on the shadow docket saying that, I think the exact procedure, anyway, basically saying that law was, they thought, probably unconstitutional. I forget the exact procedural posture. And so I think that was based on a parental rights theory, right? The parents have a right to know these things. A little weird because it's not like there's an affirmative right for the school to like actively surveil your child. And maybe there is. It wasn't one that we knew about until this order by the court. So why there's not that right, but this law that prohibits the disclosure it can be enjoined, I think it's sort of hard to know. I think the next reciprocal question is, right, is this a reciprocal parents' rights? Do parents have the same rights to make this decision when it comes to, parents who do affirm their transgender kid? Do they have a right now for their school to use the kid's preferred pronouns? I guess they don't have a right to medical care that affirms their child, but at least, maybe they have the right for the school to do that. And then there's also gonna be a second set of questions around, like, what if other students are misgendering them? Do they have some right to be protected from that? What if teachers are misgendering them? Do they have right to be protected from that? So there's a bunch of sort of open questions there as well.
Yeah, I think a big question that we don't know what the line is going to be is when these First Amendment issues turn into hostile education environment issues. Whether that is for an employee with a work environment, a student with a Title VI or a Title IX argument, and how that plays out in the future. Because Maya, going back to your original point about inclusive education, that's one of the points, right? Is to make sure that the educational environment is a good one where everybody is able to learn. And if they're being misgendered or whatever it might be, if that's impacting their ability to learn, there may be arguments there.
Yeah, absolutely. I mean, I think one of the sort of crazier parts of this sort of recent change in approach is that inclusive education was sort of created, or the sort of the research behind it shows that it actually can be very helpful in preventing the sort of hostile environments that Title VI and Title IX that are supposed to prevent. And now you have, certain states and the federal government arguing that it is the use of inclusive education that actually somehow creates these hostile environments, that it is discrimination, when it's really the exact opposite. And so I do think, the one area that we're sort of looking at next is looking to see when these laws are instituted and when they're enforced, like, what is the effect on the student body? What is the effect on teachers? And is there an argument to be made, like, whether or not this law maybe on its face is okay under the First Amendment, that it actually causes this other constitutional problem that we have to address. And so we're sort of actively looking into that. And I think that's definitely a thing to keep in mind when you're looking at the effect of these laws and how it affects students' experiences on the ground.
Yeah. Eva and Sam, y'all both talked about, what happens if parents, both parents want their kids' pronouns to be changed, or what happens if both parents don't want their pronouns to be changed in cases like North Carolina's Parents' Bill of Rights. We don't always have parents that agree, though. What happens then? Eva, what do you do in that case? We have one
And I
parent who
will
says,
tell you, that is if you have a parent objection, this is a common scenario, that you have one supportive parent and one not. And the answer is, under the North Carolina Parents' Bill of Rights, it says the parents need to be notified. It doesn't say they have to agree. Now, there are other broader, sort of references in the law to deferring to parents, and there's sort of the penumbras and emanations of the Parents' Bill of Rights. But first of all, my answer is, we do not have a blanket rule that we do the same thing for everyone, and we shouldn't have a rule like that, because each situation is different, each child is different. We've learned that in the disability context. Like, you should not, blanket rules are where we get ourselves in trouble. So my advice is, generally we would take it case by case. We would have a conversation with the parents. We might look to things like who has custody, who has physical custody. But North Carolina's statute does allow for discretion there, because it does not actually require like unanimous consent of the parents.
yeah. Another place that may come up is these opt-out pieces, right? If you have one parent who's saying, I want to opt my kid out of that curriculum, and another parent is saying, please don't. They need to learn that. I want that. Speaking of chaos, Sam, right? That can really throw things for a loop, and not as easy as a question as, we just got to notify. It really is a decision there that could get complex. Could get complex. Absolutely. All right, we've got 5 more minutes left, folks. Please add to our chat any questions that you have. But I want to make sure that I give our panelists some last words, and then if we've got time, I may ask a few more questions of big takeaways you want the audience to hear, some inspiration that you may want to offer our audience on how to get involved. The inspiration I always give folks as an education lawyer is if you care, speak. Go to school board meetings. Every one of them is going to have public comment period that is required. You are allowed to go speak. You do not have to be a parent. You do not have to have a student there. So speak to school boards and let them hear you and let them hear that there are voices on different sides of the issue. Or if you're feeling really bold, run for the school board and have really good people with good legal knowledge that understand these issues making the decisions. So many of these things are made locally. A lot of these decisions are made locally in consultation with people like Eva, and there can be a lot of impact, even if the state or the federal government feels too big. That any local school system, you may be able to make progress there on upholding kids, parents, teachers, civil rights. But I'll pass it off to our panelists. What inspiration or last words that you have for the audience? Eva, I'll start with you since I did you last to start out with. Maybe we'll go in reverse order.
I think what I would say is, as it was sort of alluded to before, school boards are public elected officials. These decisions are happening in public in meetings. And if they hear from a very activated and upset group of people on one side of an issue and not really anyone on the other side of an issue, school boards have so many other things they need to deal with. It is easy to say this First Amendment issue is not one I'm going to die on. I still got to deal with like teacher pay and crumbling buildings and all of this. And so if they're on the other hand hearing from the community and saying, boy, we're stuck in a situation here because our community seems about 50-50, that's a very different decision for an elected official. The other thing that I will say is just remember in your advocacy that school officials are not lawyers and they're not judges, they are educators. And you will have a lot more success if you appeal to them if you do not approach them as you would approach a Supreme Court panel.
Very, very good advice there. Yes, very good advice. All right, Sam, or Maya, let's go to you next.
Sure. I think what's always interesting in working in sort of the education sphere is that it is something that everyone is familiar with. Even if you don't have a kid in school, even if you're not a teacher, right? Like everyone has gone to school in some sense. And so everyone in some ways has an opinion. That can, I think, be both hard, but also great because everyone's going to has the potential to be invested in an issue. And so if you are feeling some sort of way about what's going on in your local community, it's almost certainly other people feeling that way. And if you find those people, you can figure out things to do together to push back in your environment. I think the fact that school is still largely a local government exercise, despite sort of more and more over regulation from states and federals, it is still at the end of the day decided by school boards. It's by the people in the community. And so you can have a really big effect in your community on it. You just got to find those other people and do it. And so I would encourage you all to do that.
Yeah, that's great. That's great. All right, Sam, what about you?
Yeah, I mean, I think, maybe one theme we've talked about throughout this is that, if only one side is challenging schools, then we're naturally going to get, a biased response from schools. And I think, unfortunately, my experience, especially in Florida, has been a lot of school districts just want to do, don't want people to yell at them. And so if only one side is yelling, they're going to naturally do what that side wants. And so I think when it comes to whether it's school boards, whether it's lawsuits, I think without presuming the views of anyone on this call, right? I think, at least on my side of things in favor of LGBTQ rights, in favor of students of color, I think, we are in the majority when it comes to what public school parents want. And when we make school boards, especially elected school boards, aware of that, there's things turn out a lot better. And when we use the legal rights that we have, which are still strong for most kids, we do tend to win. So when we fight, we win.
There you go. That's if it's not on y'all's t-shirts at the SPLC, you might want to put it there, Sam. You should
Yeah.
talk to your comms person. Thank y'all so much for your all of your insight today, panelists. We're so appreciative of you sharing your expertise. Thank you to everybody who joined, and whether it was live or on demand later. If you found today's discussion valuable, please share the recording with your networks. Hopefully you found some inspiration here, and we'd love for you to explore upcoming programs for the section of civil rights and social justice at americanbar.org. /CRSJ. And if you're attending the boot camp live, don't go anywhere. Our next session will begin shortly and can be accessed directly back through the lobby where you got to this one. It should be starting, I believe, in about 15 minutes. Thank you again for being a part of Civil Rights Boot Camp.